and welcome to In Conversation With. I am Mark Deem. I'm a partner in the Innovation Department at Mischon de Reya, and it is my great pleasure and privilege to be joined today by Alessandro Palembo, a legal tech entrepreneur who advises public and private entities in issues concerning legal technology and blockchain, and to companies at all stages of their commercial life. Alessandro is also the co-founder and CEO of Jure, which aims to deliver a quicker, cheaper, better dispute resolution mechanism for both civil and commercial claims, and also to provide better access to justice. Now, Alessandro, I want to explore and unpack some of the great things and the great work you're doing with Jure and blockchain shortly, but I have to say that I'm intrigued by your professional journey to date. And so perhaps a good place to start may be an explanation really of your transition, if you like, from law to where you are now firmly in the technology space.
I started my journey, studying in the law faculty of Sapienza, University of Rome. At that time, my desire, my aspiration was, let's become maybe lawyer and one day professor. So I was loving to partially study. I was loving the also academic life. I qualified lawyer in, I think, 2013, really young. Also there, I was probably the youngest or one of the youngest. I realized that probably, the chances to make an impact and to do something that can create hopefully a diverse value in society probably would have required different skill sets. I started doing startups or companies, and then suddenly after my legal practice and my bar examination, I decided to go full time doing something different from the traditional career. I didn't think that was, to me at least, that interesting to doing a traditional career. The legal field especially is a bit conservative, and the technology impacts historically doesn't scale up so fast.
You say that legal tech can be quite conservative, and what you're really combining is the vibrancy of technology with the risk-averse approach that often we see in the legal sector. Does that mean that actually working with the legal sector creates barriers for you or problems that you have to overcome?
I wouldn't, let's say, endorse the necessary association between, legal world and, let's say, slow penetration rate of in general technology. Because it depends. It depends on the service that you are providing. It depends also on which vertical you are. So if you are, let's say, selling to law firms, my own experience tells me that in the end, it's a B2B, business. So I don't think it is going to be much different if you sell to banks or financial intermediaries and so far and so on. Of course, if we think about consumer application, probably a social network, NFTs or DeFi can be faster.
I think it'd be useful for us to maybe explain for those people who are watching a little bit more about the aims of Jure, and in particular, what problem is it that Jure has identified and it is seeking now to address?
The dispute resolution so far didn't really receive a lot of attention. Why? Because, it's a complex field. What we have thought a few years ago is that things were going to change. And there is an opportunity and a really huge need that is today still probably untapped. And I'm talking about the problem of providing an hassle-free, accessible, faster dispute resolution, or if we want, justice. It's really hard for companies and people to access to an effective remedy, which is fast. We are trying to create value in that direction. So we are trying to provide to a company, an individual, a simple, hassle-free way for solving in 2-3 months a dispute for example, 100K of value in a safe, trustable environment. For the lawyers, we are trying to give them the tool for being modern lawyers in managing their clients and the dispute resolution in this field.
It seems to me that access to justice to you is not simply about enabling people to get into a court or a dispute resolution process, but also I think you are talking about access to justice in trying to level a playing field, if you like, and to provide a fair way of disputes being determined, but really trying to make this a lot more of a transparent and fairer process. Is that fair?
Yeah, it's fair. They say that 59% around of the worldwide population, they have access to internet, and this number is going to grow exponentially over the next decade. But at the same time, 49% of humanity or human beings, estimations say, have to proper access to let's say, remedies for civil and administrative needs. If you are a lawyer, you know that most of the time, the real question is, is it worth to move forward, or should we absorb the loss? After 2,000 years of expertise in this field, starting from the ancient Rome, we understood that due process, fairness, impartiality of the judge, and so far and so on are pivotal principles to be applied. And today we don't want to compromise on them, but at the same time, they require costs and high costs and time. So our really challenge is, how do we guarantee a similar level of fairness, due process, but at the same time, we reduce the costs and also guarantee a more user-centered and pleasant, hopefully delightful experience.
I'm interested about how you feel that using the blockchain can really improve access to justice and can cut through and be seen by the people who are going to be using your system to actually simplify the process.
If we want to create an online system which has a chance, I'm not saying that we will do that for sure, but has a chance to become a mainstream ODR, online dispute resolution system, we need to find a way for providing an increased trust element in the platform itself and in its processes. So our answer is, we need blockchain and some decentralized features for ensuring a higher degree of transparency. We want that the impartiality, the neutrality, the fairness of the system is backed by an uncorruptible technology.
Do you see that there's going to be a challenge for the services you're offering where the blockchain delivery intersects with the traditional legal methods, which ultimately have to take over when there's an arbitration, a mediation, or whatever form of dispute resolution? And if so, how do you deal with that?
The answer is absolutely yes. There is a complexity today of managing whatever tech product you want to have. The problem can be categorized in mainly two aspects. One is the pure compliance aspect, and the second one is the user experience. The compliance aspect implies that some aspects of blockchain technology or blockchain-based architectures probably even today are in gray areas that we can categorize as compliance problem. So a second category of problems is consists in the user experience. As per today, 2021, let's say that the blockchain user experience is still really crappy, to be honest. So if you want to use a blockchain product, you have to love the vision and the reason why you have to use it, because otherwise it's a really unnecessary pain that you are inflicting to yourself compared to the centralized version of that product. Of course, a normal user, which is really far from all these still really innovative and how can I say, really experimental world, would find extremely problematic to use blockchain products. So we had to address these two problems, plus also other minor or non-minor problems that blockchain encompasses. Our solution, which is, against the, let's say, the pure original spirit of blockchain projects, is let's adopt blockchain and decentralization progressively. We call this approach like a progressive decentralization approach or lean adapt modeling, which is made necessary, at least in our case, by the fact that we work in the end of the day in a regulated environment.
A large part of Jure's offering is about the user interface. And maybe you could just explain a little bit more about how somebody, be it a business or an individual, would approach Jure and how they'd actually start to use your services and what the experience would look like.
Technically speaking, what we offer at the private beta stage is a digital arbitration experience. The entry points for our platform are two, or the parties put in the agreement an arbitration clause which is Jure compatible. So this is case one. Case two is when the parties didn't put any clause in their agreement, but rather they will agree on the Jure platform to amend their agreement so that they will express the willingness to solve a dispute using the arbitration solution available on Jure.
And do you think your ultimate aim here is to try to remove the involvement of lawyers in the dispute resolution process?
For microtransactions, yes, to lawyerless procedure. For high value disputes, I would recommend always to let lawyers to advise you, Then there could be a middle, let's say, segment where it depends on, on many elements. But my own vision at this point is that the scope of technology, and at least of what we do, shouldn't be to, let's say, do our best for removing the lawyers, rather than to do our best for providing to everyone, including the lawyers, the right tool for charging the right amount, and at the same time providing the best service to their clients.
Well, it seems to me that rather than remove the lawyer from the loop, so to speak, what you're doing is trying to free the lawyer up to do what the lawyers are best at doing, which is advising on the law, rather than the more mundane aspects of the job, which the technology can take the heavy lifting on.
Even if technology will let the lawyers save 70% of his time, and eventually 40%, 50% of the billable hours also, this is not a loss for a law firm. The real question is the overall market size going to be increased in the next 10 years thanks to an increased level of access to justice, or rather is this market is going to be decreased? In my opinion, it's economic interest of law firms to invest in technology that cuts actually also the billable hours, not only the non-billable, because the market size is going to increase, and therefore the average, let's say, monetary value in place will be larger.
We know that technology doesn't respect boundaries or borders in the same way that we may do in the way that we organize ourselves politically or geographically. And so perhaps you could just talk a little bit about the role of jurisdiction in the juror product.
Let's start from the end. So what we built has been a first version of digital arbitration based on a standard which has been created initially at international level, and then it has been transposed in really multiple substantial laws in multiple countries, specifically as per today 168. I am referring to the UNCITRAL model law on arbitration, firstly adopted around the middle of the last century. If you look at the vast majority of, technological applications starting from email technology, there is always one recurring pattern, which is standardization and of application that becomes mainstream. And those applications are international, are transboundaries, are the same wherever you want to use them. Maybe it's the time that we provide a standardized, simplified digital dispute resolution procedure, which has a chance to become mainstream. Why? Because the learning processes that you do in one country, in one place, are going to be reused in a different place. So if you look at the data and you believe that in 10 years from now, a good component of GDP will be stored in blockchain, as a consequence of this, you need to take in consideration that you will need an effective international online digital justice standard. So that's why we started to build in that direction.
We at Mishcon have been, through the efforts of my colleague Anne Rose, helping as part of a process and a project to develop online dispute resolution rules. It's been chaired by the Master of the Rolls, Geoffrey Voss. And we are trying to promulgate certain rules which would presumably help exactly what you're doing. That is, that there is a place in the wider ecosystem for online dispute resolution rules to be generated and to form part of the wider, as I say, ecosystem for online access to justice.
As an entrepreneur, as a startup, you need an environment that set up for you the right path, or at least let you think that there will be an acceptance, an endorsement of your solution. Even if the rules are there and they theoretically would allow a digital arbitration without the hard copy, still, for being sure, it's better if we have not an handwritten, but at least a hard copy with a wet ink signature of the arbitrator. So we need, rules that actually can, dismantle myths or needs based on, different eras where technology was not in place.
Alessandro, it's been a huge privilege and pleasure speaking to you today. Perhaps we can sort of just leave with the words of Sir Geoffrey Voss, who has said that future generations will not accept a slow, paper-based and courthouse-centric justice system. He said that if that's all that's available, new generations will look for other means of dispute resolution. And that's very much where I hope that juror has a role to play in the future. Alessandro, it's been a pleasure. Thank you very much for your time. And thank you all for joining us on In Conversation With today. Many thanks.